Good afternoon. We begin with the third session, which is devoted to a role of insurance companies under the new scheme. And for this particular session, we have with us this afternoon Mr. S.P. Jain, advocate since the year 1984, which makes a journey of 38 years as a lawyer. He's a blend of many things, not only a lawyer. True, a panel lawyer of the nationalized and the private insurance companies. He is the trained mediator. He is a keynote speaker. He is also a motivational speaker. Coupled with that, he's an author of 10 books. I sometimes wonder, how do you get time being a lawyer and yet you can produce books almost in a dozen for that matter? I admire your energy and passion, both as a lawyer and also as an author. Above all, for this particular session, Mr. Jain is the most befitting person to deal with the aspect of role of insurance companies. His contribution has been acknowledged by Justice Midda as also by Mr. Vikas Pava in the earlier two sessions. And therefore, we are keenly looking forward to Mr. Jain's presentation in regard to the role of insurance companies under the new scheme. Over to Mr. Jain.
Thanks a lot, sir, for inviting me and giving me this opportunity to address regarding the role of insurance company as per the new scheme. As per the new amendment brought forth in the Motor Vehicles Act, the role of the insurance company is basically to pay the legitimate amount of compensation to the victims of accidents who are really the sufferer. And in accidents, as Justice Midda has elaborated, thousands and lakhs of persons, either they suffered injuries or their breadwinner lost their life. Now, as far as the topic is concerned, we have to look forward to aspects which contribute major and important role as far as the insurance industry is concerned. As I said earlier, that the legitimate amount of compensation has to be given expeditiously. That is the objective of the entire statute. But the compulsion for the delay in such type of cases is being that many intermediaries are involved in getting this amount of compensation from the insurance companies. And in the garb of getting this amount of compensation, there is rampant increase of implicating the vehicles in hit and run cases, as a result of which even the Honorable Supreme Court in the case of Mohammad Safiq had given certain directions when such a number of cases was brought to the knowledge of the Honorable Supreme Court, wherein lakhs and crores of rupees of the insurance companies were diverted due to manipulation by the police officials, the advocates, their colleagues, the eyewitnesses, the driver and owners of the vehicles. These instances are not few instances, but they are increasing rapidly. I have come across the cases wherein the person has brought a vehicle just for the purpose of implicating the same in the hit and run cases. And in 1 year, he has implicated the said vehicle in 6 hit and run cases, as a result of which in 2 cases, he was able to grab lakhs of rupees, and thereafter, due to one reason or the other, it was brought to the knowledge of the insurance company that there is nexus between the advocates, police officials, the claimants, the driver owner, and by way of implicating these vehicles, they are defeating the entire object of the legislation. The same vehicle was involved in 6 cases in a year. The driver was same. All the cases were pertaining to hit and run cases. The owner was the same. The counsel was the same. And this is not the only example. Even the Honorable Supreme Court reached to the conclusion that this has to be stopped by any means. When we are going to contest the cases by taking our legitimate defenses, then the question arises how we are going to scrutinize whether this case relates to the genuine death or injury case, or whether this case is a false case, in order to exaggerate the amount of compensation from the insurance company. My humble submission for this is that whenever the judicial officers, they came to know that the case filed by the petitioners relates to a hit and run case and the vehicle has been implicated, or that the fake claim case is in order to get the exaggerated amount of compensation, then not only dismissing the case is enough, but the penal law has to be taken care of, and the persons who are really involved in all these activities, they have to be punished as per law. Then only we will be able to say that the system is not corrupt. It is going to fulfill the objective of the legislation. Now, as per the new scheme of the Motor Vehicles Act, when I was going through the entire subject or the amendment of the legislation, then I came to know that there will be speedy justice to the victims of accidents as per the scheme formulated and the rules made thereunder. In my personal opinion, if we are going to go for the letter and spirit of the legislation, then there is no reason that every case cannot be decided within a period of 1 year. 1 year period is not a small period. And if we are going to the words by word of the legislation, then we can easily understood it and we can get it implemented so that the victims of accidents, they may get their legitimate amount of compensation within a period of 1 year. The process introduced by the legislation is so simple that the learned tribunals, if they are eager enough to decide all these cases in a bound down period, then there is no reason that the same cannot be decided. In my practice, I had gone through such type of number of cases wherein despite all these formulations, because in Delhi, it is going on from a long time, that the detailed accident reports are furnished by the police officials before the learned tribunals, and out of 21,000 cases, 11,000 was decided on the basis of detailed accident report. But at the same time, I prepared the list also on this aspect and found that there are cases which are pending for final arguments for years. There are cases which are pending for final orders or the judgment for more than a 6 month, 9 months, or 1 year. This system, if it is going to work as per the enactment of the Motor Vehicles Act, the Central Motor Vehicle Rules, which are going to be effected from 1st of April 2022, then each and every aspect of the case can be very well looked after within a period of 1 year, and the case could have been decided without any difficulty. Now, as far as the amendment in the Motor Vehicles Act is concerned, I would like to highlight certain aspects of the amendments which are very necessary to be adjudicated by the higher authorities, so that the insurance company may not feel any difficulty in depositing the amount of compensation. But at least the law must be clear on this aspect. My first contentions before this session is this, that there is limitation period introduced by the legislation by way of amendment, and as per section 166 subsection 3, now the application seeking compensation has to be filed within a period of 6 months, and in case if the application seeking compensation is not filed within the period of 6 months, then it will be time barred. Now, as per subsection 4 of section 166, whenever any report relating to the accident is to be filed by the police officials, then it has to be treated as a petition seeking compensation by the claimants. Now the question arises, suppose the claimants did not file the petition within a period of 6 months, and the police officials, they file the detailed accident report instead of 90 days. Suppose they are going to file it after 6 months. Now, whether the court can discard the said detailed accident report on the basis that it is time barred. In case the said detailed accident report is accepted even after 6 months, then the provision introduced by the legislation will become redundant. There will be no use of that provision, because as per the amendment, in every accident case which has been lodged by the police officials, then they have to submit the detailed accident report before the learned tribunal. And due to one reason or the another, if they are not going to file the detailed accident report within a period of 1 year, then in case the court is going to accept it, then the provision is going to be redundant. And in case the report is not to be accepted, then there will be huge loss to the claimants. Now, this interpretation has to be given by the higher or highest court, so that the insurance company may also come to know whether the case instituted after 6 months, either by the claimants or by the police officials in the shape of detailed accident report, is to be legitimate or not. It has to be entertained by the learned tribunal, or it has to be dismissed by the learned tribunal as time barred. Previously also, there was no limitation period, and as per Article 113 of the Limitation Act, whenever there is no limitation provided for the filing of the suit, then it has to be treated as 3 years from the date of accrual of the cause of action. However, in the case of C. Padma, the Honorable Supreme Court has given a different interpretation when the said period of limitation was removed from the statute. As per the dictum of the Honorable Supreme Court, when the period of limitation was removed or deleted from the statute, then they were of the opinion that it means there is no limitation period, and the suit or the petition or the application seeking compensation can be filed at any point of time. As a result of which, there are petitions or applications which had been filed even after 28 years of the accrual of the cause of action. The Honorable Supreme Court, in the case of Rohit versus Khatun B, decided on 9th of February 2017, had been pleased to dismiss the said application seeking compensation on the ground of barred by limitation. Although previously the judgments were there of the apex court that the application for compensation can be filed at any point of time. So when we are going to render the judgments or the orders in respect of the period of limitation, then this contentious issue will arise whether the detailed accident report, if it is filed after 6 months, whether can be entertained by the learned tribunal, or it has to be dismissed on the basis of Section 166, subsection 6, subsection 3 of the amended Motor Vehicles Act, which prescribe the period of 6 months as the last minute for the maintainability of the claim application for the victims of the accidents. So there is no clear-cut specification or the explanation what would happen if the detailed accident report is filed after the period of limitation that is fixed for 6 months. The insurance company at that time has to go either by the Section 166, subsection 3, or it has to be decided by the higher or the highest court, so that the issue can be cleared whether the limitation is applicable to detailed accident report or not. The second contentious issue is regarding the removal of the or deletion of the Chapter 10 of the Motor Vehicles Act. Chapter 10 of the Motor Vehicles Act was dealing with the issue of interim compensation to the victims of accidents. Now, as far as this chapter is concerned, it is deleted from the statute by amendment, And as per section 164A of the amended Motor Vehicles Act, the scheme for interim relief for claimants has to be formulated by the government, and the central government he has to decide what will be the quantum of compensation as interim relief to the victims of accidents. Who is going to pay this interim compensation? The previous Motor Vehicle Act, it was mentioned in the Act itself that in case of death, 50,000 is to be awarded as interim compensation. And in case of permanent disablement, the interim compensation would be rupees 25,000. But since Chapter 10 has been deleted from the statute, and now the power in respect of the interim relief to the victims of accident has been taken over by the central government, and till date, although the Central Motor Vehicle Rules and the Motor Vehicles Act has come into operation with effect from 1st of April of this year, but still, in respect of this interim relief, no such rules are framed by the central government, and it is difficult to assume that if the accident had taken place after 1st of April 2022 and any petition or detailed accident report is filed before the learned tribunal, then whether the claimants, they will be able to get the interim relief from the learned tribunals or not. Because no such clear-cut legislation, rules or enactment is there. What would be the amount of interim relief? Who is going to pay this amount of compensation? This is in abeyance till date. No rules are formulated by the legislation. The legislation has to formulate the rules. Thereafter, the position will be cleared. What will be the amount and who is going to pay this amount of compensation? Now, the third contentious issue for the insurance company to make the payment of compensation relates to the liability of the payment of compensation in case of the WC liability as per section 147, which was relating to the prior to the amendment of the statute. The WC liability was also inbuilt under the Motor Vehicles Act, and thousands of cases emerging from the vehicles involved in such type of cases were used to be filed before the learned EC commissioners. The learned EC commissioners, on the basis of the issuance of the policy in relation to the vehicles wherein the driver, conductor, laborer, or the examination of ticket checkers, they used to take the cases and decide the cases as per Employees Compensation Act. The said provision in respect of the coverage of the liability of the Employees Compensation Act was inbuilt as per section 147. Now, that proviso has been deleted from the statute. And now the question is whether the driver, the cleaner, the laborer, they will be entitled to get the amount of compensation under the WC Act or not. To my mind, the situation is clear that since in the definition of third party, section 145, subsection 1, the third party definition includes driver and other co-workers on a transport vehicle. Therefore, now the drivers or the co-owners in a commercial or transport vehicles, instead of invoking the jurisdiction of the Employees Compensation Act, they have to invoke the jurisdiction of the learned tribunal constituted for the purpose of MACT only. Because in case the negligence of the driver is there, then he can claim the amount of compensation under section 164 of the Motor Vehicles Act. However, in case the co-worker of the transport vehicle is involved in the accident and he is of the opinion that the accident was caused by the driver of the vehicle, then he can invoke the jurisdiction of the Motor Accident Claims Tribunal and either can file his claim for seeking compensation under section 166 or 164 of the Motor Vehicles Act. However, as per my opinion, the jurisdiction of the learned EC Commissioner as per the new act will be barred because of the deletion of the proviso from section 147 of the Motor Vehicles Act. This has to be effected as far as the liability of the insurance company is concerned. Previously, most of the cases which are pending before the learned EC commissioners, they were related to the vehicles, and insurance company in those cases were a necessary party and they used to pay lakhs and crores of rupees in case the vehicle is involved and the driver, conductor or the helper, either they sustained injuries or they have died due to the injuries sustained in the accident. This issue has to be also decided by taking care of section 147 and the other relevant provisions of section 145 coupled with the relevant enactment of Employees Compensation Act. This is going to affect the liability of the insurance company to some great extent. Now, the other aspect of the liability of the insurance company is concerned. The defenses were enumerated in the previous legislation under section 149 subsection 2 of the Motor Vehicles Act. There is amendment in the said section 149 also, and more grounds are also inserted which were not there in the previous legislation. Now the insurance company, as per the new enactment, they can take the defense of non-payment of premium and that the vehicle was driven by the driver under the influence of liquor or drug. These two defenses were not available in the previous statute. However, the other defenses relating to the driving license, permit, etc. are remain the same. The particular aspect on which we have to concentrate is, as per the previous legislation, the insurance company, in case they are going to establish the breach of the terms and conditions of the policy by leading evidence on their behalf. They used to get the rights of recovery against the insured persons. First of all, as per section 149, subsection 4 of the previous statute, the insurance company were liable to deposit the entire amount of compensation in favor of the claimants, and after deposit of the compensation amount, they were entitled, as per the judgment, to get it recovered from the insured. They need not to file a separate suit or petition for seeking the recovery rights. Rather, after depositing the amount of compensation before the learned tribunals in favor of the claimants, the execution was filed against the insured, and the learned tribunals, they used to take the coercive methods for the recovery of the amount deposited by the insurance company. In the new statute, subsection 4 of section 149 has been deleted. That was the section which provided for the rights of recovery in favor of the insurance company. Now, as per the new statute, section 150, the insurance company can defend the application seeking compensation by taking the defenses of driving license, the permit of the vehicle, no premium has been paid or the check has been dishonored which was given by the insured towards the premium for the policy, or the vehicle was driven under the influence of liquor or drug. They can still defend the cases by taking all these defenses. But the question arises, when they are able to prove the breach of the terms and conditions of the policy by the insured, then when the proviso is not there now, subsection 4 is not there now, then what will happen? Whether they will get the rights of recovery only, for which there is no such provision, or the insurance company has to get this amount out of the fund which is to be created by the central government under section 164B of the new legislation. These are the areas which are still gray areas for which no explanation is there. In case the insurance company is able to defend the application seeking compensation and they are able to establish that there was violation of the terms and conditions of the policy, then what would happen to their rights? In case the breach of the terms and conditions of the policy, then there must be some remedy in favor of the insurance company, either from the motor vehicle accident fund, which is to be created by the central government under section 164B, or against the insured, or by any process of law, for which also the law has to be decided by the higher or the highest court. Till then, it will be difficult for the insurance company to deal with the cases wherein the question of the violation of the terms and conditions will arise. The next contentious issue regarding the liability of the insurance company is based on section 147 subsection 2, which says that the base premium and the liability of the insurance company has to be established by the central government by making rules. It may be that the central government may fix the minimum premium and the maximum liability of the insurance company as per section 164C bracket 1 and bracket small k. The liability of the insurance company in case has to be determined on the basis of the premium received. Then, since the legislation is already notified, but there is no such guidelines or there are no such rules which have been enacted till date regarding the minimum premium or the base premium or the maximum liability. Till then, this will be a difficult affair for the insurance company to deal the cases which has been committed after the 1st April 2022. The central government has to enact the rules immediately so that the position regarding the minimum premium and the maximum liability of the insurance company may be on record. Till then, all the things will remain in abeyance and it will be difficult to calculate which is the amount to be paid by the insurance company to the victims of the accident. Next aspect of the enactment is whether the enactment is to be applied retrospectively or prospectively. There is no mention in the new statute or the amendment whether it will be applicable to the cases which are already pending before the learned tribunals, or it would be prospective in nature. As far as there are so many deletion and insertion in the statute is there, which are going to affect the claims of third parties. Therefore, the question is, in case the legislation has to be prospectively to be applied, then many questions will arise. Whether the liability of the insurance company, the period of limitation for which the application is to be filed, and similarly, whether the defenses available to the insurance company can be taken in the cases which have already been going on. That aspect also require consideration by the higher or the highest court. The Honorable Supreme Court, in many cases, has already decided that as far as the procedural law is concerned, it is always retrospective in nature if it is not specifically written. And in case of substantive legislation, it is always prospective in nature. As far as the Motor Vehicles Act is concerned, it is both it is procedural law as well as substantive law. It decides the rights and liabilities of the parties also, and at the same time, it decides the procedure also. And when we are going to discuss about this aspect regarding the application of the enactment, whether it is going to be applied retrospectively or prospectively, then we have to consider at least two judgments of the Honorable Apex Court, wherein the Honorable Supreme Court has made a clear distinction between the amendments which are usually and generally in relation to general amendments and the amendments which are related to the social welfare legislation. The Honorable Supreme Court in the case of Union of India versus Radha Yadav, which was decided in the year 2019, and in the case of Union of India versus Dilip, decided in the year 2020, has taken a different view in respect of the applicability of the amendments in social welfare legislation. Therefore, when the major amendments are there in the Motor Vehicles Act, which is going to affect every aspect of the adjudication, every aspect of the settlement, every aspect of the liability of the insurance company, the limitation period, etc., etc., then it has to be decided whether this enactment would be applicable to the cases which are pending before the learned tribunals, or it would be applicable only for those cases wherein the accident had taken place after 1st April 2022. This is required at the earliest because within a short period, the applications seeking compensation under the new enactment will start coming to the learned tribunals, and they have to proceed further in those cases also. And in case the dilemma is not eliminated or it is not resolved, then there will be different judgments by the different learned tribunals, which will create so many problems and difficulty, and many appeals and SLPs will be filed in order to know whether the amendment is prospective in nature or it is retrospective in nature. All these things, they are going to affect the liability of the insurance company. The next contentious issue I would like to discuss in this session is that there are certain difficulties in the assessment of compensation, and the question relating to the liability of the compensation to be borne by the insurance company is firstly related to the death of the minor persons. The cases wherein the minor had expired and there was no dependency on the minor and there was no income of the deceased being minor, the question in many cases arises whether the judgment given as far as Delhi is concerned there was a judgment in the name of Chetan Malhotra versus Lala Ram, decided by the Honorable Delhi High Court on 13th of May 2016, wherein the Honorable Delhi High Court, in the case of the death of the minors, had given a new subjective approach for the calculation of the amount of compensation. As per this judgment, the second schedule was taken into consideration and the cost of inflation in index was considered because the second schedule came into force on 14th of November 2014, and thereafter there was no increase in the national income by the central government, which was required by the central government as per the enactment. The Honorable Delhi High Court had taken care of these inflations, and at the time of assessment of compensation for the death of the child, they had used the CII method to take into consideration the inflation since the year 1994, and 1994 was considered as the base year. And on the basis of CII and the multiplier system, whatever the compensation amount was assessed, the same figure was again added towards non-pecuniary amount of compensation. This assessment of compensation was based upon the second schedule of the Motor Vehicles Act. Now, as far as the new amendment is concerned, this second schedule has also been deleted. It is no more in the legislation. When the second schedule is not in the new legislation, it means the judgment passed by the Delhi High Court in the case of Chetan Malhotra will also not survive, in my opinion. And some new law has to be developed in view of the amendment in the Motor Vehicles Act. Previously, prior to this Chetan Malhotra judgment, there was one very authoritative pronouncement by the Honorable Supreme Court in the case of R.K. Malik versus Kiran Pal, which was decided on 15th of May 2009. In that case, the Honorable Supreme Court had given the guidance how to assess the amount of compensation in case of the death of the child. Now, that judgment is also not relevant because that was also based upon the second schedule of the Motor Vehicles Act. Now, once the second schedule is not there and the death of the minors are still there, the petitions are going to be emerged on the judicial records of the learned tribunals. And in many of the cases, the insurance company used to decide the cases previously on the basis of R.K. Malik judgment, and thereafter, as far as Delhi was concerned, on the basis of Chetan Malhotra judgment. But once the new amendment is there, which is going to affect both these judgments, because both the judgments were based upon the second schedule, which is no more there, which has already been deleted. Now some new law has to be developed. And what would be the new law? What would be the liability of the insurance company in relation to the death of the child? Till then, it will be difficult for the insurance companies to offer the amount of compensation in case of the death of the minors. The next contentious issue which is in relation to the liability of the insurance company, is relating to the non-pecuniary amount of compensation, which is also substantial and is very important as far as the settlement and the adjudication of the cases are concerned. The Honorable Supreme Court, in the case of Parnassetti judgment, which was delivered on 31st of October 2017, had decided, it is a constitution bench judgment of the Honorable Supreme Court, which is applicable throughout India to all the tribunals and the high courts. In that judgment, it was specifically and categorically decided that in case of death, the claimants are entitled to get a sum of rupees 70,000 towards non-pecuniary amount of compensation, and that compensation has to be increased by 10% after every 3 years. Now, once the Constitution bench had given their authoritative pronouncement on the non-pecuniary amount of compensation, then there are many other judgments by the Honorable Supreme Court itself, wherein the Constitution bench judgment was deviated. Firstly, it was deviated in the case of Magma General Insurance Company versus Nanu, which was decided on 18th of September 2018 by the Honorable Supreme Court, and it was a DB judgment, division bench judgment, wherein instead of the compensation of rupees 40,000, which was granted by the Constitution bench judgment, the Honorable Supreme Court had given the judgment that the claimants are entitled not only for spousal consortium, but for parental consortium also. As a result, for each and every claimant, the amount of compensation was awarded towards non-pecuniary consortium amount of compensation. The question had been raised by the insurance company and by the claimants also, wherein they did not get the amount of compensation as per the judgment of Magma versus Nanu. The issue was whether the constitutional judgment is going to prevail or the DB judgment, which was Magma versus Nanu, is going to prevail. Because the judgment of Magma versus Nanu was completely in deviation of the Constitution bench judgment. Therefore, the issue is still pending. And thereafter even, there are many judgments in the name of United India versus Satinder, New India versus Somvati. And in all these cases, the Honorable Supreme Court has not adhered the constitutional bench judgment, and different amount of compensation towards non-pecuniary has been awarded, as a result of which there is a difference of opinion. And in many high courts, the high courts are going to adhere to the judgment of Magma instead of Parnassetti judgment. As a result, the settlement cases are not in tune. Either the claimants, they are going to refuse, or the insurance company, they are not going to adhere to the Magma judgment. Now, as far as the new legislation is concerned, since the second schedule is not there, and since there is different judgments of the Honorable Supreme Court on the same subject, Therefore, this is also going to create some problems for the settlement and the adjudication of claim cases even as per the new enactment. The next contentious issue which I would like to discuss is that in order to effectively handle the fake claim cases, there is a good enactment by the Central Motor Vehicle Rules. And as per Rule 25, an application can be moved by the insurance company whenever they are of the opinion that there is a fake claim and the vehicle has been implanted in the hit and run cases or fake claim case has been filed in the court. The insurance company can move the application to the DCP by requesting them to call for the record of the service provider in respect of the mobile number of the driver. In case there are cases wherein by tracing the location from the service provider, it has emerged on the record that the driver, which was shown as the driver of the offending vehicle, was not there even on the spot of the accident, and he has been implanted in the case just to facilitate the amount of compensation by the insurance company. His location was somewhere else, but it was shown, and even in some cases, the admission of the driver is there that his vehicle was involved in the accident, but actually his vehicle was not involved in the accident. He was inserted or implanted in the criminal case so that the amount of compensation can be given to the claimants by the insurance company, and later on the said drivers, they are acquitted by the courts by not having proper evidence against them. This was going on in collusion with the claimants and other persons. Now, the last my contentious issue is that to facilitate the expeditious disposal of accident cases by the learned tribunals, there is Rule 30 in the Central Motor Vehicle Rules, which are enacted and is to be effected from 1st April 2022. That evidence before the learned tribunal now can be by the appointment of the local commissioner. The local commissioner can be appointed by the learned tribunals, who can sit in the courtroom itself and record the evidence of the claimants or the insurance company. And the insurance company has to pay the amount of the professional charges to the local commissioner. In my opinion, by inserting this rule, lot of work of the tribunal will be saved, and they will be able to concentrate on the passing of judgments or orders. And by giving this opportunity to the young advocates, the lot of time will be saved and the claimants will get their legitimate amount of compensation within a short period. This aspect of local commissioner, appointment of local commissioner for the purpose of evidence, is very well going on in Haryana. I had gone there in one case, and I was really appreciate this valuable contribution by the Haryana judicial authorities, that they used to take the evidence by local commissioners. As a result, lot of time of the court is saved, and they are able to concentrate on passing and adjudicating the accident cases within a period of 1 year. This is in relation to the amendment, and lot of requirements are there But one thing is certain, that if we are able to implement it in letter and spirit as per the objective of the legislation, then the injured or the persons who have lost their life, their family members, they would be able to get the amount of compensation within a period of maximum 1 year. And this will be solace not only to the family members or the injured, but to the entire system also. If we are able to get the scheme implemented, then not only the claimants they are going to be benefited, but the insurance company they will be able to save lakhs and crores of rupees towards payment of interest, because nowadays the matters relating to accidents are kept pending for 5 years, 10 years, or some long periods. Therefore, it is for the entire judicial setup, for the claimants, for the insurance companies, for the driver and owners. It is beneficial for all these things. And therefore, the insurance company has to bond their liability wherever it is possible, and they have to give the amount of compensation, which is the legitimate right of the claimants. Thank you very much, sir. Over to Dr. Balram K. Gupta ji.
Thank you so much, Mr. Jain. I know it's not a biopsy, but a full surgery about the role of the insurance companies in this particular domain. Grateful to you for sparing the time and being with us. And we look forward to have you again in some other program as well. Kind of you. Thank you so much.
Thanks a lot, sir.
Thank you.
Thanks a lot, sir.
We are into now the fourth session of the day. And this session deals with the role of the State Legal Services Authority under the new scheme. And for the execution of this particular topic, we have with us this afternoon Mr. Kamaljeet Arora, who is presently the Member Secretary, Delhi State Legal Services Authority. Mr. Arora came to the Delhi Judicial Service in the year 1992. And then Delhi Higher Judicial Service in the year 2006. He was also the Special Judge, CBI, but since the year 2019, he has been with the Delhi State Legal Services Authority. Therefore, he is the most competent person to share with us the role of the Delhi State Legal Services Authorities, what role it plays, and how it helps the scheme to be implemented, executed in an effective, speedier manner. In fact, the entire workshop today is focused on that the time which used to be consumed in these matters was too long. And now the procedure which has been worked out is such that the entire matter can be concluded within a span of 6 months to 1 year, which is something really appreciable in this entire process. May I now request Mr. Arora to share with us the role which the Delhi Legal Services Authority has played in this domain. Over to Mr. Arora.
Thank you so very much, sir, for your kind words. So far as I'm concerned, whatever we could achieve at Delhi State Legal Services Authority, so far as this particular aspect is concerned, that could be possible only because of the foresightedness and the vision of Honorable Miss Justice J.R. Midha. I must say that he has just revolutionized so far as this particular aspect, that is grant of claims and compensation to all those who are victims of motor accidents, so far as Delhi is concerned, and now it is being implemented throughout on pan-India basis. So first of all, I'll begin with congratulating the Chandigarh Judicial Academy for taking up this very sensitive topic and for collaborating all the stakeholders together so far as this workshop is concerned, because unless and until we work in a cohesive manner, it is absolutely not possible to execute the vision or the way forward which has been shown by Honorable Miss Justice J.R. Midha in this judgment of Rajesh Tyagi versus Jabir Singh. First aspect or first order of which was delivered in 2009. And prior to 2009, I must say that it is only those persons who were aware of their rights, that in case they had met with some sort of accident and have say lost life and their legal heirs, they are aware of this fact that they are entitled to some sort of compensation. Or if a person gets injured and he is aware that he is entitled to get compensation and files a petition before Motor Accident Claims Tribunal, only then he used to get the compensation for the injuries, for the loss suffered by that person. But after 2009, by virtue of the judgment passed by Honorable Miss Justice J.R. Midha, the whole process got revolutionized. He said and made it obligatory on the part of the investigating agency, that is Delhi Police to begin with, that they are not only supposed to investigate the crime from the point of view what CRPC says, but they have to file a detailed accident report. This is what Honorable Miss Justice J.R. Mehta said before the claims tribunal, so that irrespective of the fact that whether a person who has met with an accident is aware of his or her rights or not, he should get whatever his legitimate dues are. Uh, Even otherwise, all those persons who right now are working, all those officers who right now are working with state legal service authorities, either Punjab or Haryana legal services authorities, they are aware of this fact that apart from providing legal aid and assistance, we also owe an obligation as part and parcel of the legal service authorities to create awareness amongst masses, to tell to each and every person that he or she has a right to get compensation in case he or she somehow unfortunately meets with an accident. I must say that so far as our country is concerned, it has a dubious distinction of having the highest number of road accidents. According to the latest report of MORTH, that is Ministry of Road Transport and Highways, approximately 4,49,000 road accidents they were reported in the year 2019, which resulted in almost death of 1,51,000 persons, and it has resulted in causing injuries to 4,51,000 persons. And if we see the average on a road, every accident takes place every 1.17 minutes, and it results into death of a person every 3.47 minutes. So when such sort of high percentage of road accident takes place, it becomes the moral and constitutional and statutory obligation of all the law enforcement agencies, and we being part and parcel of those particular stakeholders, it becomes our duty to do our bit. And I must congratulate Justice Mehta that the central government, whatever schemes, whatever points Justice Mehta had taken up in his judgment of Rajesh Tyagi versus Jaibir Singh, central government had taken note of this fact and made amendment in the Motor Vehicle Acts, which came into force with effect from 1st of April 2022. Similarly, central motor vehicle rules, they were also amended, and the same have come into force with effect from 1st of April 2022. For the first time, it has happened that from whatever observations were made in a judicial pronouncement, they have been incorporated in the statute. So automatically that again causes an positive obligation on all the stakeholders, on all of us who are the executors of this particular scheme to fulfill our role and responsibility so far as grant of compensation to the victims of accident is concerned, because unless and until we execute it to the perfection, it would be a dead letter, or it would say just lay in the book, and it all the schemes, all the words and observations will only be sort of paper tiger. And they always say that if laws alone could have solved the problem would have been solved by now. It is the mindset, it is the role and responsibility of the concerned authorities, it is the role and responsibility of all the stakeholders that is required to be fulfilled to the hilt, because if that is not done, all the persons who are victims of these road accidents, they would not get their legitimate due. So how the evolution of this scheme had taken place, I'll just give a brief background of this. As I have already said that prior to 2009, the victims of road accidents, they were not given compensation without filing of a claim petition. So even for the purposes of filing of a claim petition, a person needs to be aware of his or her rights. Only then he or she was in a position to file the claim petition before the Motor Accident Claims Tribunal, and that too if the vehicle was validly insured. But after 2009, for the first time, Delhi High Court came to the rescue of all those persons who were not aware of their rights, and on 21st of December 2009, Delhi High Court in Rajesh Tyagi versus Jaibeer Singh formulated the claims agreed procedure for the first time, and it directed all the claims tribunal to dispose of the claims within 90 to 120 days with effect from 2010. So, basing on the basis of the observations and directions given by Honorable High Court, so far as Motor Accident Claims Tribunal in Delhi were concerned, I was fortunate that I got a roster of Motor Accident Claims Tribunal in the year 2010, and I worked from 2010 to 2012 in Motor Accident Claims Tribunal. And during that period, on the basis of directions given by Honorable Mr. Justice J.R. Midha, uh, uh, in 2010 itself, 20,820 accident cases were reported in Delhi from 2nd April 2010 to August 2012, out of which claims tribunal were in a position to award compensation in almost 10,000 cases within the stipulated period. So these timelines are very necessary to meet, because unless and until we meet the timelines prescribed or directed by our superior authorities, that is High Court or Supreme Court, or if a particular timeline has been prescribed by the statute, it becomes obligatory on the part of the claims tribunal to meet those timelines. And in case we are not in a position to meet those timelines, the faith which the general public or the victims of road accident who are already marginalized sections of the society, that gets eroded. So automatically the role and responsibility of the claims tribunal, it assumes importance, but I fully endorse this fact that claims tribunal is not in a position to dispose of or meet the timelines prescribed by either the High Court or Supreme Court or by the statute, unless and until we get the feedback, desired feedback, we get the desired facts from the law enforcement agencies, that is the police in this case. So while working on this particular model, which was created for the first time in 2009 and which was to be given effect from 2010, certain drawbacks, certain things were noted which were required to be modified. And Justice Midha again on 12th of December 2014 modified this claim agreed tribunal procedure after taking feedback from all the stakeholders, and thereafter this modified claims tribunal agreed procedure that was implemented. And finally the Rajesh Tyagi 3, we call it Rajesh Tyagi 3, that came into existence from 2nd April 2021. And in this particular order, what Honorable Ms. Justice J.R. Midha did and said, he taking into consideration that all the role and responsibility was fixed on the police, that is the law enforcement agencies which was already overburdened. He divided the efforts which were to be put in by the police, which were to be put in by the driver of the offending vehicle, which were required to be done by the owner of the offending vehicle, or which there were certain factors, certain facts which were in exclusive knowledge of the victim, or in cases of in cases of death, the family members of the deceased. All those persons, they were called upon to provide the necessary facts within a particular period, and when all these factors were collected, the role and responsibility of the insurance company, obligation was put on the insurance company as well, that after getting all these facts, the insurance company were required to come up with a particular amount, which, if accepted by the family of the deceased, on the basis of which the claims tribunal were called upon to pass the consent award. So what I was stating earlier, that this has happened for the first time, that the observations made by Honorable Ms. Justice J.R. Midha in this Rajesh Tyagi 3 case, that was taken into consideration by the central government, and amendments were made in the Motor Vehicle Act 1988 by virtue of the 5th Amendment Act 2022, which came into force with effect from 1st of April 2022. So what has happened by virtue of this Amendment Act? By virtue of this Amendment Act, all of us, we are aware, जो इसमें पहले नो फॉल्ट लाइबिलिटी के ऊपर केसेस डिसाइड हो जाते थे, जिसमें एक स्ट्रक्चर्ड फॉर्मूला दिया गया था, that was done away with, and chapter 10 that was deleted, which was there for grant of interim compensation on the basis of no fault liability, that was entirely omitted. And so far as chapter 11 is concerned, wherein there were sections from 145 to 164, that was totally revamped, and it was new provisions were inserted, and a new chapter 11 was substituted in place of the earlier chapter. And this is a marvelous set of things which has taken place by virtue of this Amendment Act. The only thing is that now all the stakeholders, we are required to do our bit so that the faith and confidence in this judicial system, which was being eroded because of the delays in grant of claims to the victims of offenses, that gets back, that gets restored. So that is why I'm saying that this particular session is a very important session wherein all of us, we need to come together, we need to collaborate, we need to have a cohesive effort so that all those persons approaching the claims tribunal, or as and when any detailed accident report, first information report regarding accident is filed before the tribunal, that gets disposed of within the particular timeline. So as I was saying, that chapter 11 uh, that was inserted by virtue of this amendment. And as per section 149, the insurance company, an obligation was imposed on the insurance company, because all those officers who are at present holding the motor accident claims tribunal, I'm very sure आप सब लोग डिफिकल्टी फेस कर रहे होंगे, बिकॉज इंश्योरेंस कंपनी की तरफ से कोई डेजिग्नेटेड ऑफिसर नहीं आता था जो एक अवॉर्डेड अमाउंट और एक कंसेंट अमाउंट ऑफर करता था. वो ऑफर ऑफ सेटलमेंट आती नहीं थी बिकॉज there was no designated officer appointed by the insurance company before the claims tribunal. Now a positive obligation is there that all the insurance company, they have to appoint a designated officer within 10 days. Then this 10 days is from the date of accident. Now 149(2) says that designated officer of the insurance company, he on the basis of facts which will be submitted to, मैं उसके ऊपर अभी आऊंगा, that how these facts will come into the knowledge of the insurance company. Detailed forms were annexed by Justice Mida with his judgment, and all these forms have been incorporated in the new rules which have been notified by the central government. And it is on the basis of these forms, there are 20 forms given by Justice Mida, and all these 20 forms, they were incorporated in the rules, and these are various forms which are required to be filled by all these stakeholders. Some of the forms are required to be filled by the investigating agency, some by the insurance company, some are required to be filled by the owner, driver of the vehicle. So I'm coming to that. So this designated officer who has been appointed by the insurance company, he has to make an offer for settlement to the claimant before the tribunal within 30 days. That is from the date of accident. Or इसी 149(3) में again that offer when made to the complainant, it is entirely open to the complainant to accept that offer or not. If the complainant finds that the offer made by the insurance company is reasonable and he says that I accept that, then tribunal has to make the consent award within 30 days after recording the statement of settlement. So अगर complainant को लगता है, या for that matter tribunal को भी लगता है that the offer made by the designated officer of the insurance company, that is not acceptable, that is not justified, then it becomes obligatory on the part of the claims tribunal that it fixes a date of hearing and adjudicate the claims on merit. Then section 150, which has been incorporated, which is part of chapter 11, it casts a duty on the insurance company to satisfy the judgment and award against the person insured in respect of the third party risks. So whenever the claims tribunal passes award on merit, then it automatically becomes a duty of the insurance company to satisfy that award. Then section 150 says that कि अगर insured की death भी हो जाती है, so that doesn't mean that insurance company is absolved of its liability. So death of the insured shall not be a bar to claim against the insurance company. Then 158 casts a duty on the driver of the vehicle to produce the related vehicles. अब ड्राइवर के पास क्या डॉक्यूमेंट्स होंगे जो इंपॉर्टेंट होंगे, उसका अपना ड्राइविंग लाइसेंस, अगर गाड़ी की फिटनेस है तो all these documents are required to be produced by the driver of the vehicle. So it becomes his duty, statutory duty, the moment he gets the notice from the investigating officer, he has to produce all these documents. Similarly, section 158 subsection 2 imposes a duty on the owner of the vehicle to produce the relevant documents, that is registration certificate है उसका, अगर commercial vehicle है, fitness है उसकी, या उसकी इंश्योरेंस पॉलिसी है, वो सारे डॉक्यूमेंट्स ओनर को प्रोड्यूस करने हैं द मोमेंट ही गेट्स द नोटिस फ्रॉम द इन्वेस्टिगेटिंग ऑफिसर. Then section 159, it imposes a duty on the police to file accident information report before the claims tribunal within 3 months. And section 160 is there. 160 again says that it is the duty of the registering authority and the police to furnish the particulars of the vehicle involved in the accident to the victim or the claimant. तो इसमें जो ड्यूटीज हैं वो ड्यूटीज सारी अथॉरिटीज के ऊपर, सारे स्टेक होल्डर्स के ऊपर दैट हैज बीन इम्पोज्ड by this particular judgment as well as statutorily by amendment which have been made in the Motor Vehicle Act and which has come into existence with effect from 1st of April 2022. एक और जो इम्पोर्टेंट फीचर है इस अमेंडमेंट का, दैट इज empowering provision, empowering the central government to constitute motor vehicle accident fund. So section 164B, it empowers the central government to constitute a motor accident fund for providing compulsory insurance cover to all the road users in India. And again, 164C, it empowers the central government to make rules so far as implementation of this particular scheme is concerned. और 166(3) has introduced a period of limitation. पहले कोई limitation period नहीं होता था. So 166(3) has made that within 6 months from the occurrence of accident, application needs to be filed. And then it says that in case the award is of less than 1 lakh, then there will be no appeal by the insurance company. Insurance company is barred from filing appeal if the award passed by the tribunal is less than 1 lakh rupees. Now, as I was saying, कि इसमें रूल्स में भी सेंट्रल गवर्नमेंट ने जो अमेंडमेंट की, रूल्स जो नए नोटिफाई किए, वो रूल्स आर exactly the copy of the observations made by Justice Midha in this judgment, and all the forms, there were 20 forms which were annexed along with this judgment. They were made part and parcel of these rules. Form 1 जो है, that is the first accident report. First accident report, it has to be submitted in form 1 by investigating officers to the claim tribunal, and timeline is also prescribed. This particular form is required to be submitted within 48 hours of receipt of the information of the accident. And this form is also required to be sent to the respective legal services authority. Now, why this form needs to be sent to the legal service authority? एक चीज मैं अभी यहीं पे बता देता हूं, और उसके बाद I'll come afterwards when I'll talk to you with respect to the fast DAR. The first concept is a regular DAR, that is detailed accident report. Then Justice Midha has introduced the concept of fast DAR. I'm very sure that in the first session, Justice Midha must have spoken to you. He always used to tell a story about one of his friends जो किसी दूसरी कंट्री में रहते थे, और उनके साथ जब एक्सीडेंट हुआ and that person was in the hospital, the insurance company immediately came and paid certain amount to that person ताकि उनका ट्रीटमेंट प्रॉपर्ली हो जाए. So taking a cue from there, Justice Midha had thought that if that can happen in those other countries, why can't this happen in India? And in Delhi, we did that. We under that fast DAR, we were in a position to provide compensation involving the insurance company as well as the claims tribunal, and as legal service authority, we had constituted a special lok adalat, and the amount was awarded to the family of the deceased who died in an accident within 10 days. So on 1st of May 2021, an accident had taken place wherein one constable, Munshi Lal, working with Delhi police, he met with an accident. Unfortunately, he died at the spot. And I'm very sure that we cannot bring back the life of that constable who, while working, while on duty, he lost his life. But whatever solace we could provide to his family, that was in the form of FASDAR, that was in the form of collaborating with the investigating agency, with the insurance company, and by holding this special lok adalat, we were in a position to provide compensation within 10 days. And believe me, that on 12th of May, that check of the compensation amount, which was 32 lakhs, was handed over to the family of the deceased. And if this can happen in Delhi, I'm very sure that this can happen in the rest of the country as well. And we are taking the concept of that FASTDAR forward. So let me come back. So far as these forms are concerned, इस rules में जैसे amendment हुई, so initially form number 1 जो है, immediately जैसे ही accident होगा, आईओ उसकी फर्स्ट एक्सीडेंट रिपोर्ट है जिसको फार बोलते हैं, एफएआर, दैट ही हैज टू सेंड टू क्लेम्स ट्राइब्यूनल एंड अ कॉपी टू लीगल सर्विसेज अथॉरिटी. लीगल सर्विस अथॉरिटी को इसलिए ताकि लीगल सर्विस अथॉरिटी टेकिंग इनटू कंसिडरेशन दैट वेदर the victim, if he is injured, or his family members in case of death, uh, they they needed to be approached. They needed to be told that you have a right to free legal assistance, and in case you want that your claim petition or your DAR should be you want to be represented through a counsel from legal assistance, immediately a counsel needs to be appointed for them who shall assist the family of the victim to get their legitimate dues. Now, why? The question is that why legal service role of legal services authority becomes paramount or important. हम सब लोग जो इस सेशन में जुड़े हुए हैं, I'm sure that either they are police officers or judicial officers or all those officers who are say presiding over the motor accident claims tribunal, insurance company. We all know that there are certain set of persons who take away a large chunk of the compensation amount which is awarded to the victims of these road accidents, and just to make sure that this whole amount of the compensation goes to the rightful person, goes to the victims. That is why what I feel is that role of the legal service authority becomes important, and all these persons, they generally come from a very weak background. They are already marginalized sections of the society, and otherwise also as per section 12 of the Legal Service Authorities Act, they are entitled for free legal aid and assistance, and we should immediately provide a legal assistance to these persons by appointing a panel lawyer, so that that panel lawyer, without charging any amount from these persons, should make sure that the entire compensation amount should go to these victims. So that is why here comes the importance and role of the Legal Services Authority. Second form जो जस्टिस मिडा ने इसमें दिया, एंड जो सेंट्रल मोटर व्हीकल एक्ट रूल्स 2022 में इनकॉर्पोरेट किया गया, दैट इज राइट ऑफ द विक्टिम्स to know that they are entitled to legal aid, and about the progress of the case, that what are the different stages of the case, what is their role. So that is given in form 2, and this form 2 is to be given by the police, that is investigating officer, to the victim. वो अगर विक्टिम इंजर्ड है तो उसको, अगर उसकी डेथ केस है तो उसकी फैमिली मेंबर्स को विदिन 10 days of the accident. So again, this form 2 becomes very important, so that victim or the family members of the deceased should come to know that what their rights are, where they have to approach for the purposes of getting the claim or compensation. Then is the form 3. Form 3 is the we call it driver's form. ये ड्राइवर को के ऊपर ऑब्लिगेशन है which has been imposed on the driver by virtue of a statute that is section 158 which casts an obligation on the driver कि जो उसके पास डॉक्यूमेंट्स हैं जैसे ड्राइविंग लाइसेंस है all those documents, all those information driver has to supply to the investigating officer. So in this form 3 driver को within 30 days of the accident, this information along with documents he has to supply it to the investigating officer. Similarly, ओनर के ऊपर जो ऑब्लिगेशन है ओनर को वो फॉर्म 4 में अपना ऑब्लिगेशन कंप्लाई करना है एंड अगेन विद इन 30 डेज फ्रॉम द डेट ऑफ एक्सीडेंट ओनर को ये फॉर्म 4 इन्वेस्टिगेटिंग ऑफिसर को देना है. सो द होल आइडिया वाज दैट द entire role and responsibility which was initially put on the investigating agency पुलिस के ऊपर. We all know that police is already overburdened. They have to look after the law and order situation. They have to investigate the cases. They have to appear before the courts of law for the purposes of depositions and for the purposes of execution of various orders passed by the court. So despite that, although police were fulfilling their duties which were imposed on them by virtue of this judgment in Delhi, but to share this burden, Justice Midha had thought that we should bifurcate the roles and responsibility of various stakeholders so that the timeline within which the compensation needed to be awarded to the victims of these road accident should be met. Instead of imposing the entire obligation on one authority, he divided this role and responsibility on all the stakeholders. So that is why Form 3 and Form 4 they were created कि ड्राइवर के पास जो उसका ऑब्लिगेशन है, जो उसके पास डॉक्यूमेंट्स है, ओनर के पास जो documents है which are required for the purpose of disposal of the claim petition or detailed DAR, they should be given to the investigating officer ताकि investigating officer उसकी timely verification करवा ले. Then comes the Form 5. Form 5 is interim accident report, IAR. Now this IAR, IO has to supply filed with the claim tribunal within 50 days of the accident. So after getting the documents from the driver as well as owner, and after doing the initial investigations at the spot, and after getting the treatment record of the injured, IO has collected certain information or certain facts, and these facts IO needs to place it before the Motor Accident Claims Tribunal within a period of 50 days as per Form 5, which has been incorporated with this judgment. Then is the Form 6A, which is the victim's form. So whatever information is required to be supplied by the victim, अगर वो खुद है और अगर वो victim कोई minor है तो फिर 6A is there. Now this particular form, these have to be supplied by the victim or family of the victim, or in case victim is minor, the guardians of the victim within 60 days of the accident to the investigating officer. Then Form 7. Form 7 is DAR. This DAR, IU has to file with the claims tribunal within 90 days of the accident. So 3 mahine is the outer limit within which IO has to collect all these documents. IO has to conduct the verification of the driving license, verification of the RC, verification of fitness, permit, or the insurance policy from the concerned agencies, and he has to file this detailed accident report within 90 days of the date of accident. Side plan, again, side plan has to be part of DAR. This has to be as per Form 8. Then mechanical inspection report. So Justice Midha has taken pains and he himself had created all these forms so that IO need not run here and there where in what format I have to file the mechanical inspection report, in what format I have to file the verification report, in what format I have to file the site plan. So all the formats, all the templates, they have been prepared and now they have been made part of this Central Motor Vehicle Rules 2022. So Form 10, it talks about the verification report. Now again, this verification report has to be submitted by the investigating officer along with DAR to the claims tribunal within 90 days of the accident. insurance form again by the officer who has been deputed by the insurance company. He has to submit this insurance form within 30 days of receipt of DAR. So the moment that DAR is filed with claims tribunal, a copy thereof has to be given to the insurance company, and within next 30 days, the officer which has been appointed by the insurance company, he needs to file this insurance form within 30 days to the claims tribunal. अब ये सारी चीजें जब क्लेम्स ट्राइब्यूनल में आ गई, then the person who has been appointed by the insurance company, he will have to submit, जो मैंने आपको कहा था, एक offer amount, और now it is on the claims tribunal as well as on the claimant or the victims of the road accident. If that amount is acceptable, the consent award shall be passed by the claims tribunal. Otherwise, claims tribunal shall give a date for disposal of DAR and shall dispose of the petition within a period of 1 year from the date of accident. So, अगर आप एंटायर प्रोसेस को, एंटायर सिस्टम को देखें, ये फॉर्म्स और टाइमलाइंस को अगर आप साथ में हम रखते हैं, तो इन टाइमलाइंस को अगर हम साथ में रखते हैं तो एंटायर प्रोसीजर, दिस इज द फ्लो चार्ट. फ्लो चार्ट जैसे एक्सीडेंट होता है उसके बाद, जैसा मैंने आपको बताया, फॉर्म 1 फर्स्ट एक्सीडेंट रिपोर्ट, वो किसके पास जाना चाहिए? दिल्ली पुलिस से क्लेम्स ट्राइब्यूनल के पास भी जाना चाहिए, एक कॉपी डालसा के पास भी आनी चाहिए. डालसा मतलब स्टेट लीगल सर्विस अथॉरिटी, आपके उसमें उसके पास भी आनी चाहिए. सिमिलरली जो ड्राइवर का फॉर्म है, ओनर का फॉर्म है, वो अगेन दैट हैज टू कम टू दिल्ली पुलिस आईओ. फिर आईओ ये सारी वेरिफिकेशन करने के बाद 90 डेज के अंदर अंदर डार फाइल करेगा, उसकी एक कॉपी इंश्योरेंस कंपनी के पास जाएगी. इंश्योरेंस कंपनी अपना फॉर्म फिल करके क्लेम्स ट्राइब्यूनल में करेगी विद इन 30 डेज आफ्टर फाइलिंग ऑफ डार. सो दैट टेक्स केयर, वो हो जाते हैं 3 महीने डार फाइल करने के 90 डेज में, और 1 महीना और. उसके बाद ऑन द बेसिस ऑफ दैट, अगर वो ऑफर एक्सेप्टेबल है टू द क्लेमेंट, then consent award will be passed. Otherwise, claims tribunal shall conduct an inquiry which has to be completed within 12 months. So meaning thereby, if we follow all these timelines and if we follow the procedure given, which we have no other option but to follow, which have been given in this judgment and now have been made a statutory obligation on all of us, तो 6 महीने से 1 साल के अंदर अंदर the person who has met with an accident or his or her family members will get their legitimate dues, and by doing this we would be doing a great service to all those persons, and in turn what we would be doing is restoring the faith and confidence that has been eroded because of so many reasons all of us are very well aware of. तो उस कॉन्फिडेंस को रिस्टोर करने के लिए it is very necessary, it is very imperative for all of us to fulfill our role and responsibility. अब इसमें role of different stakeholders, पुलिस का क्या role है? I've already told you, police का role है, you have to give information to the insurance, General Insurance Council call center. So all these insurance companies, they are being supervised by a General Insurance Council, and they have created a call center. So a person shall be deputed by the insurance company, and that person would also visit the spot immediately after receipt of the information about the accident from the investigating officer. IO will collect the post-mortem report, get the vehicles mechanically inspected, collect all these reports, and then it will verify driving license and registration certificate of the offending vehicle from the transport authorities concerned, besides collecting other details. Now, एक चीज यहाँ पे जरूरी हो जाती है ये बताना कि अब देयर इज अ पॉसिबिलिटी कि वो जो ड्राइविंग लाइसेंस ड्राइवर का है या जो ऑफेंडिंग व्हीकल है दैट इज रजिस्टर्ड इन सम अदर स्टेट, नॉट इन द स्टेट वेयर एक्सीडेंट हैड टेकन प्लेस, या ड्राइविंग लाइसेंस ड्राइवर का है ऑफ अदर स्टेट. So a collaborative effort is being created with MORTH, or online real-time basis पे all these documents are being verified now, and all the concerned agencies are directed to assist the investigating officer, and immediately on real-time basis these documents gets verified and a report is furnished to the investigating officer so that the timelines which have been prescribed can be met. Now, what is the role and obligation of the insurance companies? Immediately on receipt of intimation, जैसा मैंने आपको कहा कि जन इंश्योरेंस कंपनी ने एक कॉल सेंटर बनाया है, उस कॉल सेंटर से इमीडिएटली द इंफॉर्मेशन विल बी पास्ड ऑन एंड अ पर्सन विल बी डिप्यूटेड हु विल कैरी आउट द इन्वेस्टिगेशन हिमसेल्फ एंड कलेक्ट द डॉक्यूमेंट्स फ्रॉम द इन्वेस्टिगेटिंग ऑफिसर, और वो इन्वेस्टिगेशन करने के बाद then after completion of the investigation by the investigating officer and filing of DAR, insurance company will come up with an offer amount. उसको अगर accept हो जाता है तो consent award pass हो जाएगा. Now what is role and responsibility of the transport authority? As I was telling that MORTH has imposed an obligation on the transport authority that immediately on receipt of request from the investigating officer, the concerned transport authority has to verify the documents which are driving license, registration document, fitness or permit, and if applicable of vehicles involved in accident within 24 hours. And they have to provide this report immediately to the investigating officer ताकि investigating officer अपना काम कर सके. Similarly, medical authorities. डेफिनेटली जितने भी यहाँ जुडिशियल ऑफिसर्स हमारे साथ जुड़े हुए हैं और प्रिजाइडिंग ऑफिसर्स ऑफ द क्लेम ट्राइब्यूनल, वी ऑल नो दैट it becomes difficult for the investigating officers at times to collect the post-mortem reports within a short period of time. And this particular thing assumes importance when I will talk about the fast DAR cases, जिसमें हम सिर्फ 10 days में हम ये चाहते हैं कि compensation amount from the date of accident within 10 days should be awarded to the family of the deceased. So medical authorities के ऊपर एक obligation है that they have to provide the post-mortem report along with the opinion as to the cause of death within a period of 48 hours from the accident. Then जहां तक मोटर एक्सीडेंट क्लेम्स ट्राइब्यूनल की बात है, on receipt of fast DAR or submission of legal offer of settlement by the insurance company, the tribunal shall hold Lok Adalat sittings in consultation with the legal services authorities, because so far as holding of Lok Adalat is concerned, it is the prerogative of the legal service authority and they shall assist the parties in arriving at a settlement. So a role of legal services authority का क्या रोल और रिस्पॉन्सिबिलिटीज हैं? डेफिनेटली इट शैल मॉनिटर एंड असेस द प्रोग्रेस ऑफ द सेलेक्टेड केसेस. जो ये सेलेक्टेड केसेस हम उनकी बात कर रहे हैं जो फास्ट डार में आएंगे. आई एम कमिंग टू दैट इन नेक्स्ट स्लाइड. लेकिन जैसा मैंने कहा कि जो फर्स्ट एक्सीडेंट रिपोर्ट है, फर्स्ट एक्सीडेंट रिपोर्ट जो इन फॉर्म 1 has to be submitted by the investigating officer within 48 hours from the time of accident. उसमें जैसे ही वो सबमिट होगी स्टेट लीगल सर्विस अथॉरिटी के पास, स्टेट लीगल सर्विस अथॉरिटी immediately shall depute a counsel who will approach the family of the victim and tell them about their rights and also of this fact that they are entitled for free legal aid and assistance, and in case they desire their matter can be pursued by the legal service authority. और आप उसमें pursue करके और you can make sure that the entire compensation amount without it being or part of it being fizzled out with the other persons, entire amount should go to the family of the victim. So immediately copy of first accident, immediately on receipt of copy of first accident report, legal service authority shall depute a counsel और वो counsel उनको assist करेगा. और इसके अलावा जो role है legal service authorities का, that is along with filing of DAR, the investigating officer is supposed to file a charge sheet so far as accident case is concerned against the driver under section 279 as and 337, 338 or 304A as the case may be. And in case the Metropolitan Magistrate who tries that particular charge sheet records conviction of the accused or the driver who has been charge sheeted, then there is a judgment which has been passed by full bench of Delhi High Court again headed by Justice Midda, and that judgment is Karan versus State of NCT of Delhi, and this judgment was passed on 27th of November 2020, and this was to come into effect from 2nd of January 2021. Uh, as per this judgment, an obligation has been passed on the State Legal Service Authority. वो obligation क्या है कि जो कन्विक्टिंग कोर्ट है, कन्विक्टिंग कोर्ट कन्विक्ट से कंपेंसेशन दिलाने के लिए एक एफिडेविट लेगी. Now, why this affidavit is required from the convict? This affidavit shall be of the financial capacity of the convict. Court shall ascertain the financial capacity of the convict and ask an affidavit from the convict to this particular aspect. और ये affidavit लेने के बाद कोर्ट उस affidavit को लीगल सर्विस अथॉरिटी में फॉरवर्ड कर देगी, asking to verify this affidavit as well as to submit a victim impact report. Now, what this victim impact report is? Victim impact report is a report which has to be furnished by the legal service authority stating the impact on the victim of the offense. उसके ऊपर क्या impact हुआ, वो कितने दिन ऑफिस नहीं जा सका, अगर वो स्टूडेंट था वो स्कूल नहीं अटेंड कर सका या स्कूल से उसका नाम कट गया या आगे की फर्दर स्टडीज नहीं कर सका, whether that particular accident has resulted in say permanent disability, or if that has resulted in death of the deceased, that person was the sole bread earner of his family. So what impact that particular incident has cast on the victim. So this victim impact report as well as verification of the affidavit submitted by the convict shall be submitted by the legal service authority to the concerned court within a period of 30 days. ये लीगल सर्विस अथॉरिटी का काम है एंड लीगल सर्विस अथॉरिटी विल डू, जैसे हम दिल्ली में इस चीज को कर रहे हैं ऑन रेगुलर बेसिस, एंड वी आर सबमिटिंग the victim impact report as well as verification report of the affidavit submitted by the convict within a period of 30 days before the concerned court, that is the convicting court, and it is on the basis of this victim impact report and the report regarding verification of the affidavit of the convict that the court passes the order on sentence and also passes an amount, the fine amount, out of which some of the amount is payable to the victim as compensation. So here also the role of legal service authority that assumes importance, and what Justice Midda has done, again a wonderful thing, although any judgment passed by superior courts that is binding on the Motor Accident Claims Tribunal, or for that matter any court subordinate to High Court, but Justice Midda, for the purposes of implementation of the guidelines which have been made by virtue of this judgment, he had created a committee, an implementation committee, of which myself being member secretary of Delhi State Legal Service Authority, I'm the convener of that meeting, and he directed that either the sitting High Court judge or a retired High Court judge should be appointed as chairperson of this implementation committee by the Chief Justice of Delhi High Court. So this implementation committee was constituted only for the purposes of seeing that all the guidelines which have been prescribed by this judgment by Honorable High Court should be implemented in toto by all the stakeholders. Now, as I was telling you what this FASDAR is, जितने भी अब एक्सीडेंट के केसेस हैं उनमें से कुछ केसेस ऐसे होते हैं which merely on seeing those cases we find that these cases can be settled at the earliest. Now, what these cases are, jahan aspect of Justice Midda has said that in those cases where aspect of rashness and negligence is apparent on the face of it and which is accepted by the insurance company as well. Number two, jahan driver of the offending vehicle is holding a valid driving license. Number three, jahan offending vehicle is validly insured. और एक और चीज, जहां अगर वो कमर्शियल व्हीकल है वहां पे वैलिड परमिट और फिटनेस है। एंड नंबर 5, देयर इज नो वायलेशन ऑफ द इंश्योरेंस पॉलिसी। जैसे जो ड्राइवर था वो शराब पी के गाड़ी नहीं चला रहा था, और ही वाज नॉट अ माइनर and was having valid driving license. So in all those cases where these 5 criterias are met, so as per Justice Mida, that particular case can be picked up and can be disposed of within 10 days. So this scheme is called FASTDAR scheme. So without any unnecessary delay, all those cases wherein these 5 criterias are met, जहां रैशनेस और नेग्लिजेंस का एस्पेक्ट में कोई डाउट नहीं है, ड्राइवर जो है उसके पास वैलिड ड्राइविंग लाइसेंस है, ऑफेंडिंग व्हीकल वैलिडली इंश्योर्ड है, कोई वॉयलेशन ऑफ परमिट या फिटनेस नहीं है, और किसी भी इंश्योरेंस पॉलिसी का वॉयलेशन नहीं है, ड्रंकन ड्राइविंग नहीं है। सो दीज केसेस कैन बी पिक्ड, एंड ऑफ कोर्स जहां पे अगर वो डेथ केस है, ये जो फास्टडार वाली स्कीम है, इट अप्लाइज टू डेथ केस ओनली, बिकॉज इंजरी वाले केसेस में इट इज एब्सोल्युटली नॉट पॉसिबल एट टाइम्स कि 10 दिन के अंदर उसका इलाज हो जाए, कंप्लीट हो जाए। सो इनिशियली बिकॉज दिस वाज अ पायलट प्रोजेक्ट, सो दिस वाज मेड एप्लीकेबल ओनली इन डेथ केसेस, और उन डेथ केसेस में जो डिसीज्ड है उसकी जो इनकम है वो एक फिक्स्ड इनकम है, जैसे सैलरीड पर्सन है वो, तो ऐसा एक केस, this particular scheme was asked to be made implementable with effect from 1st of May 2021. All of you are very well aware of this fact that last year all of us were facing the second wave of corona, and that was a very turbulent period for all of us. But despite that, we collaborated with the insurance company, we collaborated with the investigating agency, we collaborated with Motor Accident Claims Tribunal. And after doing all these exercises, we found out first case which was dealt under this FASTDAR pilot project. And that case came into our knowledge on 1st of May 2021 itself. On that particular day, the brief facts of the case are that on 1st of May 2021 at about 3:45 a.m., that right in the night, middle of the night, a road accident had taken place. A constable of Delhi Police, Munshi Lal, he was posted at the police barricade near Vasant Vihar, and a car, Honda CRV, hit Constable Munshi Lal, which resulted into fatal injuries, and that Constable Munshi Lal unfortunately lost his life, and FIR number 78 of 2021 that was registered with police station Vasant Vihar. So the investigating officer, he intimated about that accident to the claims tribunal. As I said that a grievance cell, a call center was constituted by General Insurance Council, and the person who was deputed from that council, he also visited the spot, and the vehicle in question that was insured with Bajaj Allianz Company, uh, I would say that Bajaj Allianz Company in this particular case played a very vital role, and their investigator also visited the spot, and he collaborated with the investigating officer of the case. Investigating officer, he verified the driving license in the record time, insurance policy of the vehicle, and immediately the insurance company also approached the family of the victim to verify name, age, occupation, and who were the legal heirs of that victim. So then police was called upon to furnish the FASTDAR, and our authority, that is Delhi State Legal Service Authority, we provided a legal aid counsel to the family of victim, and immediately we also convened a special Lok Adalat. Pre-Lok Adalat sitting was also convened with assistance of the concerned Motor Accident Claims Tribunal, and deliberations were made on 7th of May and 8th of May, and ultimately an award of 32 lakhs that was passed on 10th of May. That is, on 1st of May, accident had taken place. On 10th of May, award was passed after pre-Lok Adalat sittings, and a check of 32 lakhs was deposited by the insurance company with the claims tribunal. And on 12th of May, that check was handed over to the family of the deceased. So this is how the fast dar scheme that was implemented in Delhi, and I'm very sure that we can identify such sort of cases. And Justice Mehta has also made a committee of say deciding what will be those cases, or which will be those cases which can be decided under FASDAR. Definitely, for having this scheme to be in place, we require assistance of the investigating officers of the police of the concerned state. Only then we would be in a position to dispose of these cases within the timeline that has been framed by virtue of this judgment, and now by virtue of the Central Motor Accident Rules 2022. So I would say that in the background of large number of road accidents and death which are attributed to them, it is only just and rather necessary that a detailed and exhaustive system be formulated, which has now been done. And the duty is of all of us, all the stakeholders, that we need to collaborate, we need to come together for these poor victims of these road accidents. So, as has been said by Honorable the Supreme Court of India, that an explosive escalation of automobile accidents accounts for more deaths than most deadly disease, which has become a lethal phenomenon on Indian roads everywhere. So again, I'll implore and request all the stakeholders that all of us need to come together, need to join hands so that we can handhold all those persons who have lost their dear ones or have suffered injuries because of unfortunate accidents which takes place on the road. So thank you very much for giving me this opportunity. I'll thank Chandigarh Judicial Academy, and I wish that all of us shall work together so that all the problems suffered by the victims of road accident can be ameliorated to the best of our capabilities. Thank you very much.
Thank you, Mr. Arora. It has been such a pleasant presentation, so informative, and actually making a contribution in this particular workshop. We are grateful to you and we look forward to your contributions in future also in our programs. Very kind of you to have spared time, shared your contribution with the Delhi Legal Services Authority has been making in this particular field particularly. Thank you so much. Thank you.
Thank you, sir. Thank you. Thank you. Thank you, sir. Thank you.
उनकी भी क्या मेरे टच तो नहीं हो Welcome to the last session of this workshop. And this last session is devoted to procedure to be followed by claims tribunals in the new scheme. The last batsman is also in, Mr. Amrinder Singh Shergill. In fact, he's a part of us in Chandigarh Judicial Academy. He joined the Punjab's Judicial Service in the year 2004. Came to the Superior Judicial Service in the year 2015. And he came to Chandigarh Judicial Academy as part of the faculty in April 2021. He would be, in fact, consolidating the entire workshop, which we started with Justice Medda, and then we went over to Mr. Vikas Pava, the senior advocate, Mr. S.P. Jain, advocate again, and Mr. Arora, who is the member secretary of Delhi State Judicial Legal Services Authority. I'm conscious of the fact that many things must have been dealt with, and that is why I'm saying Mr. Shergill would be consolidating this particular workshop in the last session that we are having. May I request Mr. Shergill to kindly make the presentation. Over to Mr. Shergill.
Thank you so much, sir, for your kind words. Good afternoon, all the participants. We are in a workshop in which we are generating an awareness and sensitizing all the stakeholders regarding their respective roles in the newly legislated procedure which has been formulated by Honorable Mr. Justice Medda in Rajesh Tyagi case. It was modified and ultimately finalized, and now the central government has notified it and has made it a part of law. When we talk about the procedure is basically to adjudicate the claims as to the compensation to be awarded to the claimants who can be the victims of an accident involving motor vehicle resulting in death of some person, an injury to some person, or a damage to the property of a third party. The compensation for the victims of the road accident is very important. The timely dispensation of the compensation, that too of a just and fair quantum, will mitigate their sufferings. Section 168 of the Motor Vehicle Act provides that a just compensation will be awarded by the claims tribunal through an inquiry. Honorable Justice Mehta has already sensitized us that we are to hold an inquiry and not a regular trial, as it is a civil suit. The Honorable Supreme Court, in the case of Jayaprakash versus National Insurance Company, has also asked us to conduct an inquiry and not to conduct a trial, as it to be conducted in a regular civil suit. Thereafter, we had Section 169 of the Motor Vehicle Act. It provides that the inquiry is to be conducted in a summary manner through a summary procedure as the tribunal deems fit. So what we were told is an inquiry is to be conducted, and that too through a summary procedure. But what particular procedure? We were in dark, and it was a gray area. The result of the same was that different tribunals were following different procedures, resulting in disposal of the cases in a different manner. Honorable Justice Mehta took the challenge and gave to us the claims tribunal procedure, claims tribunal agreed procedure. It was modified thereafter. The Honorable Supreme Court judgments made it applicable throughout the country. But what was noticed is that the procedure was not followed in its letter and spirit. Meantime, Justice Mehta further improved it and finalized it, which ultimately was notified by the Government of India, Ministry of Road Transport and Highways, wide notification dated 25th February of this year. So, with the efforts of Justice Mehta, with the immense contribution he has provided in this field of law, now we have a uniform procedure in the shape of law to be uniformly followed by all the stakeholders. Stakeholders are the police, who has the primary role to investigate the matter of the accident, the insurance company, the claimant party, and of course the claims tribunal. Through this notification, the Central Motor Vehicle Rules 1989 were amended. It was the Fifth Amendment carried out this year itself. And through this amendment, this new scheme of procedure came into effect with effect from first day of this month, 1st April 2020. What it has done is, it has inserted a new rule in the 1989 Motor Vehicle Rules. The said rule 150A provides us the procedure for investigation of road accident. It states that the procedure which is to be followed for the investigation of all accidents arising out of the use of motor vehicle shall be in accordance with Annexure 13. Annexure 13 contains the procedure for investigation of motor vehicle accidents. This procedure has not only simplified the manner in which, from the taking place of the accident till the disbursement of the compensation amount, how the journey is to be performed, and the important part is it has made the disposal time bound. It has considered 3 different categories of cases, basically 2 categories of cases, and 1 category of cases is further divided into 2 categories. The first 2 categories are where the insurance company admits its liability. If the insurance company admits its liability, it has to give an offer in accordance with the various judgments pronounced by the Honorable Supreme Court as to how it is to be computed. And if the same is acceptable to the claimant party, then the claims tribunal is to pass a consent award within a period of 6 months from the taking place of the accident. There can be another scenario where, though the insurance company is admitting its liability, but the offer which has been given by the insurance company is not acceptable to the claimants, or the insurance company has some defense to make. In that scenario, the claims tribunal is to conduct inquiry and to adjudicate that matter. Since an inquiry is required to be conducted, the claims tribunal is provided additional 3 months, making the total time for disposal of the compensation claim within a period of 9 months from the date of accident. Other scenario is where the insurance company do not admit its liability, it has defenses, then the claims tribunal is to hold an inquiry adjudicate the matter on merits, and for that, the claims tribunal is given additional 3 months from the earlier scenario by making the total time to be 1 year. The starting date is the date of the taking place of an accident. So this procedure provides us regarding the various aspects and various stages from the taking place of the accident to the disbursement of the compensation amount to the claimants. It starts with that immediately upon receiving of an information that a road accident has occurred, the police is immediately to reach the spot. Before proceeding further, let me remind the police officers who are also attending this workshop that this is a statutory duty. This is a duty which has been put on their shoulders through a law of land. And I'll be touching that aspect also, that any duty which has been casted upon police under this procedure, under this new rule 150A of the Motor Vehicles Act 1989, shall be construed, shall be taken as a duty which the police is to perform under the respective State Police Act. And in case any of the duty is not performed, then the consequences which are provided under the relevant State Police Act will follow. So the police should immediately reach the spot of accident after receiving the information. It has to draw a site plan. It has to take photographs of the scene of the accident, of the vehicles involved in the accident. It has to get a videography done of the scene of the accident and the vehicles involved in the accident. It has to prepare a scaled site plan. In case somebody has got injured and said person is in hospital, then to reach the hospital and take the photographs of the said injury. Before going to the hospital, while doing the remaining things, what else and which is most important is to be done by the police is that it shall examine, record the statements of the persons who were standing there and who have witnessed that accident. The most important persons who can throw light as to what has happened and how it has happened. This is a very important duty, and this comes at the stage 1. After doing this preliminary investigation, within 48 hours, that means 2 days' time, the police is to intimate the sad fact to the claims tribunal by submitting the first accident report in the format of Form 1 given in this procedure. That means a written intimation in the prescribed format, Form 1, within 2 days of the taking place of the accident, it is the police which is to submit to the claims room. The same is simultaneously to be submitted to the nodal officer of the concerned insurance company, simultaneously to the State Legal Services Authority, and it is required to be uploaded on the state police website if there is any. Moment this first accident report reaches the claims tribunal, it has to be registered as a miscellaneous petition. Motor accident claim miscellaneous petition. And whatever reports are filed thereafter are to be tagged along with the same file, same FAR, the motor accident claims miscellaneous petition. After submitting the FAR to the claims tribunal, the duty put on the shoulder of the police starts. The first duty which has been put on the shoulders of the police after submitting the FAR is to make aware the claimant party, the victims of the road accident, as to their rights. And further, to be provided with the flow chart of the scheme Justice Mehta has discussed in the first session. The rights of the victims and the flow chart of the scheme is given in Form 2 of this procedure. And if somebody has died in the road accident, then to his legal representatives, this form is to be given. And the time period which has been provided to the police to do the same is 10 days. Thereafter, the police is to investigate the different aspects. One of the aspects is the validity of the driving license held by the driver. To obtain the requisite information along with the requisite document, the investigating officer will provide a blank form. The format is given in form number 3 to the driver of the vehicle, which is involved in the accident, to furnish the relevant information in that form number 3 to the investigating officer within a period of 30 days from the date of accident. By gathering this information, the police is to verify the said information, and after verifying the information is to submit further reports in the matter to the claims tribunal. If form number 3 is to be given to the driver, then form number 4 is to be given to the owner of the vehicle involved in the accident in the blank form, so that the owner of the vehicle may provide the relevant information, including the documents, the registration certificate of the vehicle, the fitness certificate of the vehicle, the permit document of the vehicle, if any. This information is again to be provided within a period of 30 days to the police, so that the police may further verify it, and after verifying it, to submit it to the claims tribunal along with the reports which the police is going to furnish. After obtaining the information from the driver, from the owner within a period of 30 days, after examining the eyewitnesses, the people who were present at the time of accident, after preparing the site plan, taking photographs, doing videography, etc., etc., the police will complete an interim report of the accident under clause 6 of this procedure in the prescribed format given under Form 5, and the report is called as Interim Accident Report IAR. Initially, we had within a period of 2 days, first accident report FAR. Now, within a period of 50 days from the accident, from police, the claims tribunal have the interim accident report. This report is also to be submitted to the insurance company so that it can also have a look into it and can further cross-verify, cross-check the various aspects and the facts contained in it. It is also to be submitted to the victims or the claimant party. It is also to be submitted to the State Legal Services Authority. It is also to be submitted to the insurer. It is also to be submitted to the general insurance company. The idea is whatever report the police has submitted after within a period of 50 days from the accident, after gathering the requisite information and thereafter verifying it, it should come in the notice of all the stakeholders who are involved in adjudicating a claim regarding the compensation to be paid in a motor vehicle accident case. Thereafter, whatever the information the driver has given in form number 3 or the owner has given in form number 4 is to be verified by the police. And after completion of the verification, it has to prepare and fill in the columns of the prescribed format, Form X, Form 10. And this Form 10, which is a verification report as to the facts disclosed by the driver and the owner, and as to the documents provided by them. And this report in Form 10 is to be submitted to the claims tribunal along with the subsequent report to be filed. That means there is obtaining of an information, thereafter is its verification, and thereafter submission of the same before the claims tribunal. What we gather from this is that the inquiry to almost most of the facts have been systematically done by the different stakeholders, the police and the insurance company, in the prescribed formats, and that verification is that information is verified, then it is cross-verified. And after verification and cross-verification, it comes before the claim tribunal. And thereafter, what remains is just a mathematical calculation, and the compensation amount is to be calculated. We had the information from the driver. We had the information from the insurance company, the owner. Now comes the stage when certain information is obtained from the claimant part as to what was the age of the deceased, what was he doing, what was his income, what is the document regarding his income, how many people were dependent upon his income, etc., etc. So as to calculate the dependence. This information is gathered from the claimant party, from the legal representative of the deceased victim of the road accident, by furnishing them a blank copy of form number 6. And for furnishing back this information in the said prescribed format, the claimant party has a time period of 60 days from the taking place of the accident. There can be a scenario when a victim who has got injured and is lying in the hospital or who has died has a minor children. If the children are there, then two agencies are simultaneously involved. That is the Child Welfare Committee to see whether that child is in need of care and protection, the Legal Services Authority to provide the legal assistance, the legal services required for that child to obtain the redressal of his grievance, his rights provided under law. And this information will be in a different format. That format is Form 6A, which is again to be given by the police to the claimant party, legal representative of the victims, to be furnished back within 60 days from the taking place of the accident. Form 10 is the verification report of the police. On the other hand, a cross verification takes place from the insurance company as to the particulars which have been furnished by the claimant party in Form 6 and Form 6A provided by the police to it. Then the said verification is also to be submitted to the claims tribunal. After initial investigation, first accident report, later investigation, interim accident report, all the information which is gathered is verified, cross-verified, and a final report is prepared by the police, called as detailed accident report. The format of the same is provided in form number 7 of the procedure, and the time period which has been fixed for submitting the DAR is 90 days from the date of accident. The DAR will be accompanied by all the relevant documents, the site plan as per format given in Form 8, mechanical inspection report of the offending vehicle as per the format given in Form number 9, as per the verification report format Form 10 of the police, and the report, the Challan report submitted under Section 173 of the Code of Criminal Procedure. This copy of the DAR is simultaneously to be provided to the victims, the claimant party, the owner, the driver of the offending vehicle, nodal company, the nodal officer of the insurance company, the General Insurance Council, and the State Legal Services Authority. In the said process, it may happen that the information which police is seeking from the driver, from the owner, is not being provided to them. is the documents are not being provided to the police. Police is not helpless. What it has to do is, under clause 14 of the procedure, to approach the claims tribunal, move an application seeking direction to the defaulting party to submit the requisite information directly with the tribunal within 15 days from moving of the application. So the police is not helpless. If the cooperation is not given by driver, owner, insurance company, claimant, police can approach the tribunal, can obtain the directions, and in that scenario, the information is to be directly given to the claims tribunal within a period of 15 days. After receiving the FAR, we have registered a miscellaneous petition, motor accident claims miscellaneous petition. Now the DAR has come. After the receiving of the DAR, which is to be treated as a claim petition, it has to be registered so. But sorry, I was missing one thing. That there can be certain circumstances which are beyond the control of the police to submit the interim accident report within 50 days or the detailed accident report within 90 days. And the said reasons which are beyond the control of the police can be that it is a case of hit and run accident. The culprit, offending vehicle could not be located. The parties are residing at a distant place outside the jurisdiction. The driving license is from a distant place outside the jurisdiction from where it has to be verified. Or the victim are in hospital and they are not in a medical condition to suffer their stay. In those exceptional cases, what the police is to do is to approach the tribunal and seek the extension of the time. As per the facts and circumstances of the particular case, the claims tribunal is to grant the extension. But again, only for those exceptional reasons which are beyond the control of it. After the receiving of the FAR, IAR or the DAR, what the claims tribunal is to see is to examine it, whether they are complete, they are in the prescribed format, the requisite documents are there, and if it is not so complete, then it will ask the police to complete the deficient formalities when all those have been produced before the claims tribunal. Not after receiving the DAR, But after obtaining the presence of all the concerned persons through the police, through the investigating officer, the DAR or the FAR which was registered as miscellaneous petition to which IAR was tagged, to which DAR was tagged, is to be registered as claims petition, the regular claim petition, motor accident claim petition. And if the police is unable to produce any of them, then it will obtain the notice to be served on the responsibility of the IO, on the concerned person, and procuring of the presence of that person before the tribunal will be the responsibility of the police. Now, there can be two scenarios. The DAR discloses a case of rash and negligent driving. If it discloses the case of rash and negligent driving, what is to be done by the claims tribunal is to register the claims petition under section 166 of the Motor Vehicles Act. If it do not disclose the rash and negligent driving, or the claimant party chooses to obtain instant compensation on no fault basis, then the said DAR, after procuring the presence of the concerned parties, is to be registered as a claim petition under section 164 of the Motor Vehicles Act. Hereafter, the important thing which has been done by this very procedure is that the inquiry is to be conducted. The inquiry is to be conducted for the satisfaction of the tribunal regarding only those aspects which the police or the insurance people are not able to confirm. And for that, section 165 of the Evidence Act is to be invoked. As Justice Mehta has said, the tribunal is to take the driver's seat in conducting the inquiry as per this procedure in a time-bound manner, and it is always free to summon the concerned person and put a question on behalf of the claims tribunal to know the exact matter, to know the better truth. Thereafter comes the stage that the tribunal concludes the inquiry, consent award, or meritorious adjudication of the admitted liability compensation amount or the disputed liability compensation amount. Before passing the award or at the time of passing of the award, the claims tribunal is to examine the claimant party. The purpose is to know what is their financial condition, what is their financial need, how much money they will be requiring per month for the annuity scheme in which we have to deposit the compensation amount as told to us by Justice Mehta, and how they would like to get that money. And for that matter, the claims tribunal is to obtain from the claimants the Aadhaar card, the PAN card, the details of the bank account, which is Aadhaar linked and which is near to the place of the residence of the claimant party, 2 sets of photographs from the claimants, and 2 sets of specimen signatures. And this information is to be mentioned by the claims tribunal in the award itself by directing the respondent to pay the amount in the said account. Hereafter comes the deposit of the award amount. It has to be in the annuity scheme. How much amount is to be disbursed, when it is to be disbursed, it will depend upon the facts and circumstances of the case, but it has to be protected by the claims tribunal so that if it remains unprotected, the entire effort will go in vain. Hereafter comes the most important part, which will help us to a great extent, is that there is a format given in this procedure, Form 15 in death cases and Form 16 in injury cases, where we have to incorporate in our award the summary of computation of compensation. How we have computed, how we have calculated the compensation. And then there is a prescribed Form 7 format, which is again to be mentioned in the award, which is the compliance of the procedure, this procedure. And we can have the assistance from the litigating parties by obtaining written submissions from them in the prescribed form. This is, in short, the overview of the new procedure. Do go through it. Do read every provision carefully. There are specified formats given in the forms thereafter, which will be helpful in adjudicating the claim cases within the prescribed. With this much, I thanks each and everyone for the patient hearing. Thank you so much. Over to you, sir.
Thank you so much, Mr. Shekil. Short, crisp, and yet covering everything.
Sorry,
that is
sir.
what is required as such. With this, we are also concluding the workshop today. I feel that this workshop has come out very well, having the first session with Justice Midda. I specifically acknowledge his contribution and grateful to him for having spared the time and made rich contribution. Not for the workshop alone. He is, in fact, the one who has been instrumental as a judge, and thereafter imagine that the rules were framed in such short time. Normally, when a judgment is given by an ordinance, they would try to overrule the judgment. But here is one particular judgment which has been translated into actual practice through the medium of rules which have been framed in this particular context. And thereafter, Mr. Pava, Mr. S.P. Jain, Mr. Arora, and now Mr. Shekil, all of you have covered the different aspects. I thank each one of you and look forward to the contribution in the future workshops that we intend working out in the Chandigarh Judicial Academy. Thank you, everyone, particularly the participants who have contributed by being effective participants